provided copies free as an initial kind of rollout. We provided 2021 copies to the Rental Housing Association, so that landlords could get copies from RHA. And we are hoping to firm up a more formal arrangement for future providing the public with the handbooks. So that's something we're actively working on. You can still print it off on the homepage at seattle.gov/renting in Seattle. There's a little instruction there about how to print it off most expediently and efficiently, but everyone's printers are different, and it doesn't always follow that it's the same for everybody. The reason why we ended up going with the Renter's Handbook versus the sort of bunch of pages of typed content that we used to have is that it is designed to be something that's kept and referred to. Also, it's much more understandable. It's in plain language. There are illustrations to help people understand the content. But because there has been so many changes to our rental regulations in the past 12 months, it is being required to be updated, which I'm working on at the moment. I'm very close to finishing the updates for the 2022 version. And I will send a copy of that out on the landlord listserv, and there will be a copy available on the website too, obviously. But we take your point that the book is not as readily available or accessible as it should be, and that is something that we are continuing to work on around the challenges of COVID. So now I'm going down to, so Angie asked a question about pulling the rentals. I think I explained already that we don't know that. I don't even know if there's a reliable way of knowing that information. I don't deal with the Rio Data, but you can always call the helpline and talk to somebody if you want specific figures for something, but I don't have that information. Another question from Angie. I'm just reading these in the order that they're written. For the school term moratorium, is there any exemption for landlords with just 1 or 2 properties, or do we have to have financial reserves adequate to cover all costs for potential of 9 months or more as a new standard? So it does not apply to landlords with 4 or less rental units, Angie. Okay, Steve, is the city of Seattle doing anything to support small landlords who have mortgage payments to make and can't do it without rent from tenants? Well, I do know that the rent assistance that was available, the monies that were made available, federal funds and city funds, landlords were able to apply for help through that. But I believe registration is closed for landlords now. In terms of mortgage assistance, I don't believe the city is doing anything with that. I would check in with Rental Housing Association or Washington Multifamily Association, because they will be the most up to date in terms of what resources there are for financial resources there are out there for landlords. Okay, the next question is Rosie. How do tenants of moderate to low income household prove they qualify under that category? So currently we administer a program called Tenant Relocation Assistance Ordinance, and that is when tenants are being displaced by development. So if somebody's knocking down the building you're living in, or they want to change the use or something like that, that requires a licensing process. And relocation assistance is paid to low-income tenants as well. And in that case, they basically submit proof of income to the city, and we check through employment security, and we ask for tax returns, or we have a whole bunch of acceptable documentation of income. So basically, we require the tenant household provide us with documentation of income, and then we run the numbers to see if they're eligible. Okay, another question from Angie. Thanks for speaking to that, but who can provide Rio Data if not SDCI renting in Seattle? So if you want to call the helpline number or SDCI's complaint number and ask for that information, you will get it. It's just that I don't have it for you right now. The rental registration program is its own program. It's housed in the same department, but it's not something that I deal with directly. So again, if you want information on Rio or Rio Data, then you should call SDCI and ask for that, and somebody will give it to you. How can small landlords, this is the second part of your question, how can small landlords understand the context of how other small landlords are reacting if the city doesn't have that info? I don't even understand that question. Don't even understand what that means. So I'm going to the next one. Okay, Alec, you felt the need there to clarify about the 4 or less units. Do you want to say something else about that?
I think there was some expression about what is being done for small landlords, and and just sort of there are exceptions in the rules. I would, you know, if I was going to answer this question, I'd rather be looking directly at the rule, because you know, the school year exception has certain requirements. The winter you know, the winter prohibition on terminations has its own requirements, but I do believe several of them have exceptions built into them. So I don't know if the group wants us to go through and really focus on what is available for small landlords in the code and just break it down. Is that something everyone wants to hear right now?
Well, I mean, I would say that as the slides show, the school term moratorium and the winter moratorium do not apply to owners with 4 or less ownership interest in 4 or less units in Seattle. So that's very clear. Most of the exemptions that apply to the winter eviction moratorium that I went through also apply to the school term moratorium, except for owner elects to sell. I believe that is the only exemption that applies in the winter eviction moratorium that does not apply in the school term moratorium, is that you want to sell your single family property. That's the only exemption that does not, that they don't have in common. Okay. Langdon Miller, what might constitute examples of imminent threat to safety? You know, I mean, I guess to a degree that's sort of a subjective thing, but I think to meet sort of the burden of proof for a court, it's a reasonable person standard. So if somebody makes threats, or if somebody you know, does something physical, or, I mean, I think we all know what a danger looks like. So if a tenant is dangerous and there is a real threat to health or safety, then it shouldn't be something that you have to kind of mull over. Is this really dangerous or not? If it's imminent and it's real, I think it's going to be pretty obvious. But you can always call the helpline if you have a tenant that you think is an imminent threat to health and safety, and talk to them about what they think or what they're seeing is coming across coming across to enforcement as examples. I know that we've been getting a lot of them because it's the only exemption to the COVID-19 moratorium. But again, we don't know how many of those prevail in court. We don't know that information. So we don't know if if a landlord is going forward with that kind of a 3-day notice and the court is saying, no, you haven't demonstrated that the tenant was an imminent threat to health or safety. So we don't know, basically, ultimately is the answer. But I think it should be clear to somebody when there's something threatening or dangerous. Will the presentation slides be available publicly after this workshop? Yes, this presentation is being recorded, so you'll have access to that. Is from Angie again. Is eviction the same as just cause? I'm not clear. Okay, so eviction is the physical act of putting somebody out of a property. Just cause is what you have to have in order to do that in Seattle. I'm not clear if you were talking about non-renewal of fixed term leases or evictions for other reasons or both. Non-renewal is different from eviction, correct? Non-renewal is different from eviction because you're basically saying, I have just cause to not offer you another lease. But if the tenant refused to move pursuant to a just cause notice to terminate their tenancy, you would have to go to court to physically evict them. Is that clear? Yeah, so Alex says it there much more succinctly. You have to fit any termination into just cause. Just cause must apply anytime you don't want to renew a lease or you want to terminate a lease agreement. Why are these slides titled eviction if it's not all related to eviction? Not renewing a lease is a standard contract action that comes up sometimes. So we're just trying to make it simple for folks. That's all. I mean, if you're not renewing somebody's lease because you say you have just cause and they want to stay, I mean, to them, it's an eviction. And so we can, we can split hairs on the interpretation of the word, but basically when I used it in the presentation, it's to describe the mechanism by which you can put somebody out of your property, okay? Okay, another question from Angie. Wow. I would ask RHA or other legal experts for the best language, but please don't overuse eviction as it's confusing. Okay, I think you've made your point on that already. What affects whether a lease converts to a month-to-month? That would be in your contract. It would either be in the lease agreement itself. It would say this, when this lease expires, it reverts to a month-to-month. Or if it just expired and you accepted rent for the next period, then you're basically establishing a month-to-month tenancy. What does it mean in the comments above where Alex McKeon says the criminal legal activity is being addressed? Alec, can you speak to that?
I think that question came just a minute before you were covering that as a just cause reason. And I think it was in one of your slides. So I didn't realize that it would get, I didn't realize where it would land in the comments where it's decontextualized, but I think you brought it up. And then I think you'll find that there's another question about kind of what is criminal activity. And I'm just like, what constitutes that? And that really is kind of a thing that the courts, you can go to trial on those issues. If you need to evict someone and you have a enormous factual dispute about what constitutes an imminent threat, I don't think that's something we can sort of give any sort of bright line definition for. Do you, Dulce?
Sorry about that. I was muted. Well, if you think about it like this, you're standing in front of a judge and you have to convince the judge that you have a right to put this person out on the street with a 3-day notice. So you have to meet the burden of proof. Generally speaking, when a landlord uses illegal activity or criminal activity, there's an arrest record, there's a police report, there's something to demonstrate that there's illegal activity. But just always remember, the burden of proof is going to be on the person who's trying to evict. So you have to have sufficient evidence to show that this person can be put out on a 3-day notice. I think, let's see, somebody who finances relocation assistance. This is a question from Steve. So if you're talking about the relocation assistance for this new economic displacement bill that kicks off in July, that is the landlord. The landlord will pay the relocation assistance, but the bill requires the city to advance the money. And then we send out a letter, we will send out a letter to the landlord, and they have 10 days to reimburse the city. And it'll generally be about 3 times the amount of rent for qualified households. There are other relocation assistance for different types of scenarios, but I think that's the one that you were talking about, Steve. Is that right? The bill that goes into the economic displacement relocation assistance bill that goes into effect in July. If a landlord has to pay the city 3 times the rent, can a landlord have a payment plan? That's a good question. In general, I don't think we do payment plans. I'm trying to think, because again, this bill is new. So, but based on other programs that we do, I mean, I can remember one time taking money in installments from a landlord in an emergency vacate and close. That was one time many years ago. So I would say probably not, but I couldn't answer for sure, Nancy. Lynn, what is the cost and how do we get one? Are you talking about the renter's handbook? So the cost is probably going to be about $4 or $5. We haven't definitively settled on it yet because we don't have a distribution source as yet. So a lot of it will depend on that. The city is required to subsidize the cost, and we will largely subsidize the cost. We're trying to keep it as affordable as possible, but it'll probably be about $4 or $5, maybe a little bit more, approximately. Right now, the 2021 one, I think Rental Housing Association is out of them, but since the 2022 is just about to get published, that's what we'll be focusing on, and we haven't had those printed yet. So we'll put the online version on first, and then again, like I said, we're working on this distribution plan for the books, so there's a more consistent way and source for landlords to be able to get these renters handbooks. In the meantime, you can print them off www.seattle.gov/renting in Seattle. Rosie, what are the requirements for registering our rentals for the city of Seattle? Is this still a requirement? Yes, it is a requirement, and you just want to call the Rio helpline or the Rio number. Alec, do you have that to put in there? I don't know if I, let's see. I'll put that in the chat, the number to call to register your property.
I'll get it there in just 1 second.
Okay, thanks, Alec. Karen, does Seattle housing rental law pertain to storage only structures? No. No. No, it applies to residential, and I believe it also applies to commercial properties. So if somebody is paying for storage, maybe it does apply actually, but that's not something that we deal with. We don't deal with commercial tenants. So I'm not the one to answer that. I would probably, yeah, I'm not sure. We'll see if we can get you an answer on that, but commercial, I don't know if storage only is going to count as a commercial. I mean, the point of the moratorium is to keep people housed and to keep small businesses going who are renting commercial spaces. So I'm not sure if storage fits into that, but we'll see if we
I
can
mean,
find that out.
unless the storage is part of the tenancy, like if you're renting a storage space in the basement, as part of the lease, then
Or
maybe.
it's on the or it's part of your, like it's the garage, detached garage in your backyard that's part of your rental. It's part
Yeah,
of what you're renting. Yeah.
but not if it's just a storage space, then you're in a, we're not involved.
Well, see, I'm not sure. Well, we're not involved regardless, but I'm not sure about whether the moratorium would cover it, Alec, because it could be protected under the commercial moratorium. Like
Yeah, like
if somebody's using storage for furniture because they have a furniture shop, or they're doing, I mean, I don't know, but basically we don't know. Is the answer. We
yeah,
only deal with residential tenancies. Is that correct that the school term eviction moratorium does not apply to small landlords with 4 units or less? I thought it was just the winter eviction moratorium that had the exemption. If both do, that is good news. My understanding was that it applies to both, but I'm going to double check now, because if I got that wrong, that's not good. Actually, will you check that, Alec? Will you check to see if it applies?
Yeah, I'll check.
Yeah. Debbie, where would you suggest as a resource for application and lease templates that include language appropriate to Seattle laws? So I would suggest subscribing with a landlord association, like the Rental Housing Association is probably the main one for Seattle landlords. I use their paperwork for my rental property. They're very diligent about making sure that they're up to date. We have a good working relationship with them. So if they ever want to know anything or looking for clarification, they call us. And we have an open dialogue. So I would say the Rental Housing Association is the best resource for landlords in Seattle. And they provide rental agreements, they provide notices, they provide anything basically that's in writing between a landlord and a tenant. Heather, can you please post the slides you shared along with the recording of this meeting on your website? I believe that is the case. Okay. Okay, so we do need to have an answer on that exemption of 4 units or less for school term. Did you come up with that yet, Alec? Let me see.
I'd say the answer is that I'm actually having quite a bit of trouble getting back to the screen that displays the meeting.
I'm gonna look it up. I'm gonna look it up here on my phone. 1 second.
Let's see.
I actually have the bill printed out. I'm just gonna go get it and just read it. Just give me a second, please.
I think what we're going to find as a preliminary is that the 4-day rule, or I'm sorry, the 4-unit rule does not apply. And so apologies for that, but I'm going to put something into the chat right now. And these are exceptions. Eviction may occur as otherwise allowed by law if the reason for terminating the tenancy is due to conditions described in subsections E, J, K, L, M, N, O, P. So you can see there's several exceptions that may not address. I believe that paragraph E is for the sale or for moving in a family member. And then I would want to look at the rules to go through them so that I would be precise. But section P is also the one that we've been talking about, imminent threat. So there are ways, if you have one of these reasons, then you can, these are available if there's a certain situation arising. But it does appear that school year does apply to small, less than 4 units, I think. But we'll let Dulcie weigh in on that in just a moment.
Yeah, I just went and retrieved the actual ordinance, and I'm just reading through it now. So just bear with me, please. Alec, you can maybe look at some other questions or keep the chat going.
Yeah. Let's see. So looks like so I'm going backward in the chat. So maybe we could Dulcie can skip that one and get to it. It says on a 10-year-old month-to-month written contract with the only thing I have in writing with my landlord, if he wants to elect to sell his home here or raise the rent more than 10%, how long do I have to live here? It would take a long time for me to be able to find housing more than 30 days. So this is a question from Lynn Brevig, and I think that you should be getting more notice than 30 days, because if the owner is going to sell their unit, they need to give you a 90-day notice, and it can't end in the middle of your period. So that should not be happening on that timeline. If the lease says that it can, if the lease agrees, essentially you've signed something that says we can use our own timeline, there are waiver protections built into Seattle Municipal Code, so we can say it applies. The rule about just cause applies even if the lease says that it's waived. You can't waive just cause. Even if you sign something, those protections will still apply, of course. So that's another question. Dulcie might still be reading, so I'm going to go to the next one. Does the law address how much rent can be raised with a new lease? And this is from Steve at 148. And I'm going to guess that this is a question about economic displacement, relocation assistance. I don't think the law, I mean, I think the way that this is set up is that you can raise the rent as you see fit. If the market is advancing and you need to raise the rent, that's okay. What the rule is telling us is that when is the notice required? And then if the notice is required, then tenants have the opportunity to apply. One thing I would emphasize with economic displacement is if a tenant applies for this assistance, it means that they will be leaving the unit. So if it's a reasonable rent increase and it's affordable to the tenant, there's a lot of incentive for them not to apply if it's still a sustainable tenancy for them. I understand there could be some skepticism about that, but Dulcie, are you ready to jump back in or?
I am. My apologies. That was an error, and we'll have to correct the slides. The 4 units or less only applies in the winter eviction moratorium, not in the school term moratorium. So the school term moratorium applies to all landlords, regardless of how many units you own. But as Alex said, there are still exemptions. So basically, we have owner needs to move in. Owner needs to move into the unit themselves or have an immediate family member move in. We also have, let's see, EJ. Again, the illegal unit is another reason. Reducing the number of individuals. Basically, all the ones that I listed, except for owner elects to sell, apply. But the big error I made is that the 4 units or less only applies to the winter eviction moratorium. That exemption for landlords only applies to the winter eviction moratorium. So I will correct those slides, and I'm very sorry about the confusion. This should show you how we know how difficult it is for small landlords when we as the subject matter experts are struggling ourselves to keep up with the amount of legislation and the amount of detail and also interpreting laws that haven't even gone into effect yet. So so again, my humblest apologies for that, and thank you for whoever pointed that out. I think it might have been Angela, maybe. Is that her name? Well, whoever, thank you very much. We'll make that correction. I'm sorry about that. Is everyone clear on that? Okay. Did somebody answer Lynn's question? Let's see. Let's see. Apply, is that exempt or not for 4 or less? Let's see. Yeah, okay. So I'm going down here to Nancy Pelton. Apply, is that exempt or not for 4 or less? There is no exemption in the school term moratorium. No exemption for landlords who own whatever amount of properties. There's no exemption. That only applies in the winter eviction moratorium. That's the only thing. And that you can't use the reason to sell when you're dealing with a household with school children. You can't use the reason to sell, but there are a bunch of other just cause reasons that apply. Okay, Saron, I guess with the winter and school term, no eviction policies, it becomes impossible to evict families for non-rent payment, correct? Correct, not even a question, correct, exclamation point. Well, that's not true. I mean, if families are committing illegal acts, if you need to move into the property yourself, if you get a notice of violation because the unit's illegal, if there's an emergency condition, there are quite a few situations where somebody could still be evicted. But does it make it more difficult? Absolutely. It doesn't mean you can't evict them for non-payment of rent. It just means you can't evict them for non-payment of rent during that school period. The rent is still due and payable, and you can still pursue the tenant for the rent. But yes, it does make it much more difficult. Absolutely. If I am asked, this is Lynn, if I am asked to leave my home because the landlord wants to sell the house, how much time do I get to live there with a month-to-month rental agreement? And Alec answered that actually, and it's the 90-day notice is required for the sale of a home, 90 days, not including the date of service. Okay. Does anybody else have any questions? Are there any questions unrelated to the content that we presented that you'd like to ask? Because this is your chance to basically access us for anything that we might be able to share with you. So, and if people want to get on the mic, I think that would be okay now. What do you think, Alec?
Yes, if it goes, we can always mute if it's too much, but yeah, go for it.
Yeah.
My question is I had asked to know which pages of the pamphlet were changed because I have already printed several to have them ready to go. And so it would be more cost efficient for me just to change out the pages. Where would I find that? I know you have the PDF on the site. Where would I look for which pages to switch out?
I mean, I guess I'm just going to have to, I mean, there are edits that are just improvements on what was written before, and then there are details on the new laws. So are you just wanting to know where the material changes are, like where it's about a new law or there's an update to an existing law, as opposed to just anything that's been edited on a page?
I would say if it's been changed, I would want to switch it out so it's totally accurate. But if you just said change page 10, 12, 14, 19, 33, then I would know to just change those pages.
Yeah. I mean, I guess you're the first person to ask, so I will keep account of it. I will keep account of it, because I'm sure if you're asking, somebody else will have that same question or that same thought. So it's not, it's almost there, but I will. Can you send me your email, Nancy? And when I am done with the edits, I will email you and let you know.
Certainly. And
Very
can you
nice.
give me can you put your email on here for me so I can,
Sure.
thank you. I appreciate that.
You're welcome. You're welcome.
It seems that we're actually picking up some questions in the chat that are pretty involved answers.
We are.
It says,
Oh, okay. I see. I see. Okay. Let me go through. I'll go back. Let's see. Okay. So back to Angie. I do not understand how to mitigate risk around the new roommate law. As a small landlord, it seems to say I have to enter into a long-term contract with any friends or family of the original tenant. Is there really no exemption for small landlords from this law? I don't believe there's any exemptions. It just is what it is. And I really, I don't know how to talk about mitigating risk. I mean, I guess, you know, you can screen any roommate, but if they're family, you still can't deny them tenancy. So I mean, at least you'll have that information. Is there an exemption for owner occupied units? I'd have to look at that. Just haven't been using these ordinances enough where I'd be confident answering that. Alec, can you check that? I don't think there is.
do they mean owner occupied? Like, is there an exemption to the roommate bill for owner occupied?
Yes.
I would say.
Well, I was just saying there isn't an exemption based on the amount of properties you own for the roommate bill.
Oh, right.
But I was just wondering if a property, if there's an owner occupant exemption. I couldn't remember that. Do you remember?
Well, it would depend on a couple things, but in general, if you look at Seattle's just cause ordinance, not during the moratorium, an owner can terminate on a 20-day notice with just cause if they occupy the premises. And that's an old rule that is still on the books. So that's still available. I don't think that went away.
On a month-to-month agreement, a landlord can do that.
Right.
If
So
the tenant is on a lease, they can't.
but
So
that should be self-explanatory, I think. But yes, I mean.
okay, so Angie, I'm sorry I don't have a more satisfactory answer. There are no exemptions, that's for sure.
I do think I would say on that though, if there's more people in the house, I mean, the idea is that they'll be able to continue to pay the rent, right? That if there's more people to share to get the rent paid, that's one of the concepts. And then if they're non-family members, you can ask them to join the agreement. And that way, if there is a deficiency at some point, you have more pockets to go after. I mean, I think that's how some landlords are looking at it.
Well, that's good. I didn't have that perspective, but thanks for sharing that, Alec. Also, we have been, as a department, when advising or talking to tenants who want to add roommates, talking to them about the inherent risks for them, because if somebody takes on new housemates, those housemates have some rights, and if things get difficult or if there's some sort of conflict, it can get pretty messy for the original tenant. And so we do sort of, talk around that with tenants who are asking about roommates.
I have a question.
Okay.
May I? Why aren't the laws also including Airbnb type rentals?
I think the COVID eviction moratorium does, but I don't believe our regular non-emergency order, COVID-19 moratorium, they're not, because they're not considered residential properties. Now, I know that if somebody is renting something consecutively for 30 days and beyond, they may then have residential tenant rights. But for the most part, the city considers Airbnbs as sort of like hotels or commercial interests. They're not about long-term homes for people. Okay, so I'm going to go back to the chat here. There's a Jamie Kingham. When landlords have to go after tenants for not paying rent, how often do they actually recoup, and what is expected timeline? I have no idea how to answer that. That would be sitting in court and watching every day and taking, or finding data somewhere, but we don't have that data. We don't track that.
I do know that landlord attorneys are always keen to make the judgment as large as possible. So they are, and they have, I don't know what goes into collecting judgments, but I think that's something, great question to ask a landlord attorney.
Yes. Heather asked how often are inspections needed? I assume that's to do with the rental registration inspection ordinance, and I believe it's once every 5 years or once every 10 years. I can't remember. The rules changed on that recently too. And then obviously if there's a complaint, we go in and inspect, but in terms of the obligation for rental registration, I believe it's once every 5 years or once every 10 years. Alec, can you look that up? I'm so sorry.
I will take a crack at it. It's not a question that our unit answers, but I will take a look.
Yeah, we don't enforce the group that Alec and I mean, I work alongside them. They don't enforce the Rio requirements per se. They can enforce around them if there's a tenant involved in something, but we don't generally, that's not a program that we administer us directly. Okay, let's see. Jay, if I choose to occupy a unit I am renting out, how long do I have to live there before I can rent it out again? So if you terminate a tenant because you want to occupy the property yourself, or an immediate member of your family want to occupy the property, you have to live there for a minimum of 60 consecutive days within the first 90 days after the tenant leaves. And if you rent it out or list it or don't move in or just put your toothbrush there and think that that's going to make it look like you're living there, those things could all result in a notice of violation and a fine from the city and a private right of action from the tenant. Okay. Post the best websites for landlord information and support. So our website, which I'm going to type now, is the main city resource for anybody involved in renting, tenant or landlord. Be patient because we're still updating our information on there also. And then again, I would refer people to the Rental Housing Association or the Washington Multifamily Association for landlord advocacy. Okay, Nancy, explain maximum number of tenants on a property. So that particular just cause we were talking about is an older just cause where in a single family house only up to 8 unrelated people could live. Alec, has that come into play with the roommate bill at all? I mean,
I have not seen it applied a single time yet.
Yeah, it's not something that comes up very often. It's usually
like 0 times in the last 2 years. 0 times. But we can, on the Rio thing, by the way, while I've got the floor here, and believe me, my unit would see it. We would talk about it if we had seen it. So, I mean, it's like it's not just a molehill; it's a tiny molehill. So when it comes to the Rio, there's a random methodology that, and there's ratios involved based on size of units, but I believe that their goal is to have an inspection on every property in Seattle every 10 years. So you should have an inspection at some point within 10 years of your initial registration. So, but I do think that if I start going on about it, that I'm really out of my depth on that one. So
No, that's a good answer. It's once every 10 years. I knew it was 5 or 10. I knew it was is one or the other. So basically subsection K of the just cause eviction ordinance is the one that I referred to briefly on the PowerPoint about the maximum number of individuals. And this has been part of just cause for a long, long time. And under Title 23 of the Land Use Code, basically there can be no more than 8 unrelated people living in a single family unit. Now, again, rarely in my, I don't know, 10, 12 years of enforcement did this come up. And when it did, it was usually in these kinds of rooming houses where there might be 15 bedrooms, and that's what would happen. So it doesn't really apply when it's this is not related to the roommate bill, and the roommate bill in any case has a very liberal definition of family. So I mean, obviously that was deliberate. So those two things are not really related, in case that's the connection that you were making, Nancy. Okay.
I think this last chat question is pretty important from Bev to everyone.
Okay, I'm going through them in order. There's a question from, I hope I don't murder your name, but Serafan Yas. So, we're not the legislators. We're not the ones who decide what laws to put in place. So these questions are not really relevant for us. We're just trying to help you understand the technical requirements. But if you want dialogue about why, and then you need to engage with your council members and the mayor's office. I mean, we could have a lively discussion on what should have happened, could have happened, would have happened, or the burdens on small landlords. I mean, it's not controversial to say that there's been a huge burden put on small landlords. It's the fact. But I can't tell you why that decision was made, because I didn't make the decision. And so again, these kinds of bigger topics are these sort of philosophical differences and stuff. That's something that you have to talk with your electeds about, because we don't have any control over that. We're just city workers trying to do the best we can to help people understand what they're supposed to do, and trying to understand what we're supposed to do, because it's it's a lot. Okay, let's see. Alan Sebring, am I a landlord if my girlfriend pays me rent in my house, or is that a shared expense? You know, whenever somebody pays you for something, it could be said that that's establishing some sort of contractual understanding or agreement or exchange. I mean, the definition of a tenant is somebody who, you know, resides in a unit pursuant to a rental agreement. Sometimes we've had to, you know, parse out in complicated situations if someone is a tenant or not. But I would say whenever somebody is paying you in exchange for something, you need to think about what that means, and you should probably talk to an attorney. Generally speaking, couples don't consider each other landlord or tenant. So it's kind of like a trick question in a way. And yeah, so, you know, that's the best that I can answer that. Do you have anything to weigh in on with that, Alec?
I think that's a good answer. Good answer.
Okay, so now, Angie, I'm not asking about owner occupied. We have single family rentals and the concern about the new roommate laws that a tenant can move in and anyone, how to mitigate risk of all the eviction moratoriums and requirement to offer lease renewals to new people who we didn't originally rent to. Well, again, I mean, you already asked this question, kind of, and we already said we can't really tell you how to mitigate risk. You can screen anybody that is being added as a roommate so that you can get that information that you may need to know. But you know, I don't really know how to answer that question. You have a rental agreement, you have rules, you have just cause. So if any of those issues come up, you have a way to, you know, enforce your rental agreement. As far as risk, we don't, that's a hypothetical thing. I don't even know, if that's not really a discussion to have here. That's not something that we're equipped to tell you how to do. Steve, can you please discuss short-term versus longer-term rentals? Steve, if you mean Airbnb, or do you mean like something that's being rented for 3 months versus a year? I mean, I'm not sure what it is you mean, but if you mean Airbnbs or vacation rentals, those are not considered residential tenants under the code that we enforce. It could happen if they ended up staying for a long time. They could trigger protections under the law, but in the city's eyes, there's a difference between a short-term rental. It's not considered a tenancy versus a residential tenant. From Debbie, reading the RHA blog, it appears that we can no longer write term leases that automatically convert to month at the end of the term. Am I reading that correctly? So Debbie, I would have to go and read that. I'd have to read that. I haven't read that blog, but there's no reason why you can't have a lease agreement that reverts to a month. Now, maybe RHA have made a decision about how they want to write their contracts and stuff. I don't know. I haven't seen this blog. And if it's a blog, is it other people talking, or is it representatives of RHA? I don't know is the answer. But legally, in terms of what the city's requirements are, there's nothing wrong with having month to month, it reverting to a month to month at the end. And if it does, you don't even have to do an offer of first refusal. You can just let the lease roll over. You can still give a rent increase with 6 months notice. You can still change the lease terms if it's month by month with 30 days notice. So I'm not, you know, the answer is I don't know what RHA is saying on their blog. Okay, more opinions from Angie. Again, I would encourage you to share those with people who actually can do something about it. Is your city organization new or doing business for years? This is by Ingrida Gray. So the department has existed for many, many years. I mean, I don't know, 80 years, 90 years, something like that. The Renting in Seattle program is just sort of a banner over information facing outward to the public. But our enforcement program and our housing inspection program has been around for decades. We just started organizing information and access from the public under a Renting in Seattle banner so that people just know where to go for the information.
Thank you, that helped.
You're welcome. For rent increases for yearly contracts, if planned increase is less than 10%, do we still need to give 180 days notice and use the suggested hard notice language, or can we do it through email within 60 to 90 days? Due to seasonality, it is generally harder to estimate well the summer market rate during a winter month. Okay, that's a lot. I have to read that again. First of all rent increases require 180 days notice, regardless of the percentage. That's the first piece. The second piece is any rent increase or any notice that's going to materially affect a tenant, and raising their rent is the material impact, has to be a attempted personally served notice, hard copy. If you want to, as a secondary way of sending it by email, you can, but that cannot be the only way that you issue a notice. It has to be in writing, hard copy, and you have to try and personally serve it. And that language has to be on every rent increase, that hard language. And excuse me, not that. When we say hard language, the eviction language about right to counsel, that's on a 14-day pay or vacate, a 10-day comply or vacate, a 3-day notice to quit for nuisance or waste, a 3-day notice to quit for criminal activity. Anything that says or vacate has to have that CAPS language about the right to counsel. The other language about if you want to know more about your rights or this notice, call Renting in Seattle, that has to be on every notice. And then there was another question. If planned increase is less than 10%, well, I've answered that, so it doesn't really matter. From Bev to everyone, if it is done within 60 to 90 days, both parties may be able to decide better. I'm not sure what that means.
One thing I would be curious about is if you say you give a large rent increase to a tenant, and they come and say, well, 6 months ahead of time, and then they say, well, we're going to move out, and you say, well, I don't want you to move out. I mean, you could negotiate with them at that point, right? Like, they're probably not going to complain to SDCI if you lower the rent increase to retain them, right?
I'm sorry, I'm typing in the chat here. Yeah, I mean, when we're talking about rules and stuff, we're talking about requirements. The relationship between you and your tenant is between you and your tenant, and there are ways to communicate and negotiate and all of that. We're just telling you what it is you have to do to avoid not complying with the law, basically. But there's a lot of soft skills and relationship stuff that goes on between a landlord and tenant that the law doesn't really speak to. Okay, so I just retyped. So Susan Lacey asked, what's the best way to access all of the new laws? Are these city laws? Are these state laws? Is there a centralized website where we can get the information we need? So, I mean, that's a really, did somebody want to say something?
What is it?
What's that?
Space.
this Sarah that's trying to talk?
I don't know. So first of all, the laws that we discuss are Seattle city laws. We don't have enforcement jurisdiction over state laws. So we only ever discuss laws that are specific to Seattle and Seattle city limits. Our website, which I just posted, is the best for city-specific information. And again, I will say, disclaimer, we are still trying to add all the new stuff and keep everything up to date. So, you know, bear with us. But for the most part, you'll find all you need to know on that website. If not, then you call the helpline at 684-5700 and get through to one of our analysts to help you understand what it is you need to know. State laws, I mean, you can go on the RCW and read through the actual code, which is kind of difficult. But I think probably some of those landlord advocates have summaries of state laws as well. We don't do that though. We have enough with our own city laws to have to do that. I mean, in general, if a landlord is looking for guidance on something and they call us, we can speak to state stuff, generally speaking, but that's not what we're primarily here for. We're primarily here to enforce Seattle regulations. But we will always try to help with information or guidance, or if you were looking for something in the state Residential Landlord Tenant Act, we could help you find it, something like that. Susan Lacey, it seems like information is readily available to renters, but not to landlords. Actually, Susan, I would disagree with that. And our website is set up for landlords and renters. So if you're a landlord, you can click a specific button for landlords. If you're a renter, you can click a specific button for renters. We actually do a lot more outreach to landlords, and they're a lot more responsive as well. Tenants generally have nothing in common other than the fact that they pay rent, and that's really not enough to make them or to motivate them to gather to know about information. Generally, tenants will only want information on an as needed to know basis. So if they get crossways with their landlord or they're in trouble with their tenancy, then we'll hear from them. But in general, the landlords are really a big focus of what we do. And prior to COVID, we had 4 to 6 workshops a year for landlords, attended by about 150 each time. So I would disagree with that. What I would say is that the burden is on the landlords to know more than the tenants, because you're the housing provider and you're the contract provider and you're the one who has to know what rules you need to follow in order to have this business. Whereas a tenant just gets their rental agreement, and as long as they follow the rules and pay their rent, that's really all they need to know until they need to know something else, which is when they call us, which is usually when there's trouble. Heather R., what is the length of time before an Airbnb renter might convert to fall under these laws? 30 days? Also, would it matter if the person were renewing short-term weekly stays? Alec, do you want to answer that?
I think 30 days is, let me start. 30 days is a good point of concern. When these arise, they're usually factually intensive, and we will ask questions if the person is receiving housekeeping. Do they have their own phone line in the premises? That's an archaic question now, I think. But like, we do try to ask questions, you know, is this something that was set up this way or not? But once you do cross the 30-day threshold, it does become much riskier that the person might be able to assert that they've established a tenancy. So I would keep that 30 days as a good alert sort of flag point, like what's going on here. You know, I think that's a good marker.
Yeah, at some point when somebody's paying to stay somewhere, they do get covered by rental protections. And so 30 consecutive days is considered sort of the mark whereby you start establishing a tenancy. So somebody has a question here, Nancy. On the 60 to 90-day notice, and the tenant has 30 days to respond, what if they do not respond, and what should the landlord do? So I haven't had that question. What about Alec? Have you had that question from any landlords yet, or has it happened yet?
I don't think we have had that yet. So, and that's, I, so the 60 to 90 days, you've given a just cause reason to terminate in that situation, right? So they are terminated. Or wait, oh, you've given them
No,
the
it could
offer.
be,
Apologize.
yeah, it could be the offer of first refute. So I think Nancy's asking, they give a notice between 60 and 90 days of an offer of a renewal, and the tenant doesn't respond within the 30 days. What happens then?
Let's see.
So Nancy, did you mean an offer of a new rental agreement?
Yes. Because I'm not sure my tenants, I mean, I've done this for like 25 years, know that they would have 30 days notice. I mean, 30 days from once I give it to them to respond.
Right.
I mean, I don't know if that's
written on the page.
Yeah. So the thing is after 30 days and they haven't
Responded.
what should I do?
I mean, so I do think there's a rule that says that under the RCW that says for all tenancies of well, that's for specified time. I mean, it could revert to a month-to-month tenancy at that point.
But what if I don't want a month to month and it's in my contract that it doesn't go month to month?
Oh, so it is definitely a terminating lease.
Yes.
And I believe, so when I'm looking at RCW 5918.650, we don't enforce this. I'm just reading the language from paragraph D. For all other tenancies of a specified period not covered under B or C of this subsection, you'd have to go look that up. And for tenancies of an indefinite period on a month-to-month or periodic basis, a landlord may not end the tenancy except for causes enumerated in subsection 2 of the subsection. Upon the end date of the tenancy of a specified period, the tenant becomes a month-to-month tenancy. So that's state law. You know, I'm not quite sure how to interpret that, but I think you're might be right about that it would revert month to month. And then
well, I mean, so let's just say you had a rent increase in there. I mean, like if you had a rent increase, so first of all, the rent increase takes 6 months, right? So let's just say you give notice of a rent increase and then sent the new rental agreement with the new rent increase amount. So 6 months before the end of the agreement that you're in, you say, I'm going to raise the rent when this lease expires. And then between 60 and 90 days prior to the expiration, you send this rental agreement to the tenant and they don't respond. Well, I think that Alec is probably right, that in order to end the tenancy, you'd have to have a just cause. But if the tenant just doesn't respond to the rental agreement, I think, but they stayed and they kept paying rent, then you'd have them on a month-to-month basis, but with all the terms of the new agreement and the new rent amount. And if they didn't pay the new rent amount, then you'd have to evict them for non-payment.
Okay.
So we would have to return their money then.
No, that's not what she's saying. Okay.
You could only do that though. So the way it is now is that the only way to get a tenant out is either because you have just cause or it's a mutually agreed upon or negotiated. So, yeah. So you wouldn't give the money back.
I think this is hypothetical, but I think too, if you were trying to introduce a new rule in by saying, hey, there's some new information in this new lease, you properly serve them, more than 60 days. That meets the state requirement. So if there's a new rule about don't stack stuff up on the deck, that, they've received notice of that. And I think you can rest upon that. So I do think if you are in that kind of situation where you're like, we've got a problem here with, and we're trying to address that in the lease, I think that's also addressed.
And the last part of my question I posted a little bit later is when I'm not even talking about rent increase. I'm just saying the 60, 90 days with the new contract. Do I also need to be, along with the contract, do I need to provide them a notice to vacate form as well? Or is that something that they would have to write me back?
So they have 30 days to respond. So they could respond and say, no, we're leaving, or they could say, yes, want to sign, or they could say, let's negotiate. And so I'm sorry, what was the last part of the question again?
Do I need to provide a notice to vacate along with the contract or just the contract?
No, I don't, that's not required, right, Alec?
I don't see that requirement. I mean, it might be a good
Mhm.
practice, might suit you, but I don't see that as a requirement.
Okay, thank you.
Okay. Tristan, is there anything around tenants leaving dogs in the home for 24 hours? There's nothing in city municipal code for renters at least, but you could put something like that in your rules, that there can't be any unattended animals for more than 24 hours. So that would be something that you would choose to put in your rental agreement if that was something that you wanted to enforce.
And we may not know what animal control would say too, right? If you have a complaint of, a pet that's in trouble or something.
Yeah, that would be a separate issue. But they do take noise complaints for unattended animals, or if an animal is being neglected. So that's definitely a resource you could use. But in terms of where the law in rental law speaks on pets, it's pet deposit, and and service animals versus pets. Those are the sort of areas where the law regulates, where city municipal code regulates. Lynn Brevik, did I hear you say that my landlord would have to give me notice 180 days in advance to increase my rent? I have a month-to-month agreement in a residential duplex unit. Yes, all rent increases from November 9th, is it? Or November 8th or 9th onwards have to be 180 days at least. Have to be in writing, have to have the proper language on the notice, have to be a full 180 days, not including the day of service.
Exactly.
And if somebody does get a rent increase that doesn't have the proper amount of notice, please call the helpline, because they will require the landlord to rescind it and issue it again, and they'll have to start over. And so for landlords, you really need to get it right. And for tenants, you really need to make sure that the notice you're getting is proper. Any notice you get as a tenant, you should call and talk it over with somebody to make sure that it's proper. Okay. So Saron is saying sorry. I'm not sure. Oh, my kid's unmuted. Oh, okay. That's okay. I have those too. Can you link to the specific area of the site that recaps all the city laws? So I don't know what that, there isn't a one page with all the laws. It's just not possible to do that. So you go into the area that you need. So are you looking to know about what you need to know about listing your property? Are you looking to know about evicting somebody? Are you looking to know about charges, or repairs? You find where you are on the website in the story, and then you find the relevant information that's there.
Yeah,
Except not all of it is up to date. I keep saying that because that is a disclaimer. We are still working to get all of that information in there. But for the most part, it is up to date and you can rely on the information on it.
there's a lot of going back and forth. You know, if you have SMC 7.24 is never going to be in the same place as SMC 22205, which is not going
And
to
this is why we don't. So this is the challenge of trying to basically communicate technical legalese to a general population audience. Most people, myself included as a landlord, don't want to be given code, being cited code 7.24.030. That's generally what an attorney is going to be looking for. What the landlord generally wants to know in plain language is, what do I have to do in order to comply with the laws? And that is definitely contained in the website, depending on what it is you want to know. Now, would it be useful to have a page with all the new laws that have been passed in the last 5 years? Yes, but we don't have one of those, if that's what you're looking for. Or the past year, do we have a one page that lists all the laws? That might be something that we could look into doing. But you still, the website is designed to take you from the minute you want to rent something to somebody all the way to returning their deposit at the end, and everything that happens in between. So you just find where you are, what information you need, and you should be able to locate it. But in terms of how those laws are written and organized under different municipal codes, that's not what people want to know, for the most part. From our years of doing outreach and engagement, that is not what people want to know. And there's no perfect way to communicate all of this to everybody. There just isn't. So we just try and take feedback and do the best we can in terms of what works for people. Okay, Nancy's already asked that. Angie, when I have called the rental helpline a couple of times this past year, it gets routed to city employees who don't know anything about landlord law. They say a specialist will call back, but no one has ever called back. I have gotten replies when I've sent email, but not had luck by phone. Well, I'm sorry about that. That's not acceptable. The way the helpline works is that everybody that calls that helpline gets through to a technician who then has to basically triage your call and send it to the relevant person. And then that person is supposed to call you back. If you're not getting calls back, you should call back and ask to speak to a manager or a supervisor, because everybody should be getting called back at the very least. It mightn't be as quickly as you like, depending on our staffing levels and on what's going on any given day, but you should always be getting a call back. It's not acceptable if you're not. So please follow up with a supervisor or a manager and have specific details about the time and who you spoke to and whatever else. Email is often the best way to get hold of us now, because we're not in the office. We're almost all working from home, and it's much more difficult to manage a phone line from home. So email is often a more successful way to contact us, just so you know. Okay. As owners, Susan Lacey asks, as owners, are we allowed to leave our units vacant instead of renting them out? Yes, that's your prerogative. As long as how you emptied out the unit was done correctly in terms of getting rid of the tenants, then it's up to you if you want to leave a rental vacant. Heather, read the Airbnb length of stay question. Thanks, that makes sense. Some professionals, example, traveling nurses, end up staying longer, like if they were still looking for housing. It sounds like part of the landlord's counter argument would be showing such a conversation that their understanding is if the person was still looking for long-term housing, correct? Sorry. Excuse me. I have a little bit of a cold. So like Alec mentioned earlier, when we have had situations where somebody is claiming to be a tenant and the landlord is claiming that they're not a tenant, we look at a whole bunch of different things. We usually have the tenant fill out what's called an indicia of tenancy, where they have to answer all these questions. Do they get their mail there? How long have they been paying rent? Do they have rent receipts? Is there a rental agreement? Is there proof of payment to the landlord? Is there proof of paying utility bills? There's a whole bunch of stuff that we would look at and interview both parties to try and determine. But as a starting point, if you are allowing somebody to stay in a property belonging to you and they are paying you for that permission for 30 consecutive days or longer, you possibly have a long-term residential tenant on your hands. That's as specific as we can be in answer to a hypothetical question. What do you think, Alec?
I think that's a good answer. I think if somebody doesn't want too much, I think a lot of people wouldn't want the hassle. Like if you really need them to go out, you say like, you know, if you in good faith have rented to them as an Airbnb and you want to use sort of the hotel rules and say you've got to leave, they might just leave, right? I mean, your understanding is that they are in an Airbnb and nobody's, you know, and I think another thing along what Dulcie's relaying is usually when we see situations, the person has sort of become trapped there. They don't have the means to move on. And that's when we sort of get into those messy situations where a pipe has burst or, you know, something. It's usually not people with economic means that are demanding to be tenants, because if they stop paying rent as tenants, you can actually get them out. You can get them out quicker than it can actually be a faster process. Maybe not than a hotel. In a hotel, you can say you're trespassing now if they're not paying anymore. So I don't know. I mean, you have options. And if you're, you know, I think it's a question of good faith. As long as that's what's happening, you can proceed with what you in good faith believe.
Well, I mean, good faith is obviously number one, always in every situation in life. But I also would say talk to an attorney and make sure that whatever document you're using, whether you want to call it a short-term vacation rental contract or a rental agreement, whatever it is, just make sure it's ironclad and protects you and says exactly what the agreement is. But if it looks like a duck, and it walks like a duck and it quacks like a duck, then it's a duck. That's what we say, you know, when it comes to determining whether somebody is a tenant or not. Heather says, how do you prove receipt of hard copy in person? So a lot of the standard forms that you'll get from providers like RHA will have a little thing at the bottom of a notice that says received by, and then you can have the tenant sign to say that they received it. Or, you know, have a witness with you or take a picture or, you know, I mean, generally speaking, if somebody has taken delivery of something in person, they're not going to deny it. But as a best business practice, any way that you can substantiate that you have given this notice to this person on this particular day is a good practice. Okay, scrolling down. We have 2 minutes left. So the effective date, Bev, for the rent increase notices was from November 9th. So any increase from November 9th on has to be 180 days. And let's see.
I just added a survey. Anyone, and I know there's been some comments made about the presentation. So this survey would be a great opportunity to give feedback. It's in the chat. So I think that is a nice way for some people to register sort of, you know, some ways to improve or things you liked.
Yes, don't share the things that you didn't like. I'm just kidding.
We'll accept positive feedback just like negative feedback.
Okay, and this is the helpline.
Quick question. I came on late, and so I'm not sure if you already covered it, but if you want to limit it to fall under the long-term rental and be 30 days, no less and no more, can I beef up that? And it's done through Airbnb, let's say. Has that already been addressed and I can watch the recording?
I'm sorry, I'm not sure what you're saying. And we're out of time. We're out of time now. But if it's related to Airbnb, we don't deal with Airbnb. We had a couple of questions about what constitutes a tenancy. And we talked about that a little bit, but we don't deal with Airbnb. They're considered businesses and not residential tenancies.
Okay, great. Thank you.
You're welcome. And I think isn't it facilities, and who does the business licensing again for Airbnb? Is it FAS?
I feel like it was FAS, yes.
Yeah.
And
Yeah,
they,
so-
yeah.
Yeah.
And I'm assuming you have to sign a contract with Airbnb. There could be a lot of things that we're not tracking here. So there's, what your relationship is with Airbnb, what your obligations are to the guests. Like we're not tracking that.
And then somebody asked about an email. So I've given you the helpline number, I've given you the website, and I'm going to give you the online complaint form that you can use to reach SDCI. It's not renting in Seattle specific, but that's how you can communicate via email. Thanks, Lynn. We try. Again, I just want to apologize for putting some wrong information out there. There is no exemption for 4 units or less when it comes to the school term moratorium, just the winter eviction moratorium. Just wanted to say that one more time. Again, I apologize that we missed that in the presentation. But it should just show you we're all in the same boat trying to come up to speed with all of this new stuff. So I'm going to put a link in for the complaint line. I just have to find it. And that concludes our presentation. Thank you so much. And